Hey, welcome to the Employment Law Show. And if it's your first time, come on in. Water's warm. Lots of stuff to teach you about employment law and workplace rights. If you're returning, welcome back. Love to have you here. John Scholes, Lior Samfiru. Lots of stuff to cover in the show today. In fact, everything you need to know about maternity and parental leave. This is a huge topic, and employers get this one wrong all the time. So we're going to correct them as well as educate you. So stick around for that. First, pal, I want to give away the contact information: 1-855-821-5900. Help at EMPLOYMENTLAWYER.ca, or simply EMPLOYMENTLAWYER.ca is the website. There you can catch the place to land for our radio show. And from the radio show, we always play phone calls back in this show. So we'll get to that in due course. But first, as we always start, the week that was. What is brewing?
It's been terrific.
Okay.
You know, on a recent show, we were talking about the pocket EMPLOYMENTLAWYER.ca. We'll talk about that more on the show. But a lot of people have used that tool and made them realize that they have entitlements that they didn't know they had. So they reached out to me. So I've spoken with so many people, even more than usual over the past week. It's terrific. I'm so happy about that. I'm glad that I have the privilege of reaching a lot of people through this show and help inform and educate and spread the word that the laws here in this province, when it comes to employment law, they're good, they're extensive, and they protect employees. But the law can't help you unless you understand what it is and what it does and how to enforce it. That's what we're here to do. That's why we're on the TV and we're on radio and we're all over the place to make sure that you know what your rights are. If you have a job, lost a job, are undergoing changes to your job, maybe you want to come back to work after a disability leave, your rights, your entitlements. We cover it on this show. We cover it on the radio show. If you're not sure what that means for you, if we don't cover your specific question, we'll give you my information. You can call me. You can email me. We can talk about that. But to kind of get us really revved up here, one situation that came across my desk, just one of many, John. I could really pick many matters, but one in particular that I wanted to bring up. I spoke with a lady who worked for a fairly large retailer for 2 years. Now, before that, she had a job at a different retailer. She had it for about 10 or 11 years. The manager at this retailer contacted her. They knew her just from trade shows and whatnot, and said, "We think you'd be a really good fit for our company. We want you to come work for us." Eventually, she agreed. So 2 years ago, she changed retailers, went to work for this other company. Fast forward 2 years, that manager that hired her is let go. She's no longer with the company. Maybe she even retired, I'm not sure. New manager comes in. New manager says, "You're not what we want. We're going to let you go." Now, it sounds unfair what I've just described, but so far, the company has done nothing wrong.
Right.
They're allowed to let her go. Even though, hey, she did nothing wrong, it's the manager changing. They're allowed to let her go. But here's where the wrong comes in. They say, well, you've been with us for 2 years. We're going to give you 3-week severance. 3-week severance. Well, is that right? Well, no, it's not right. Now, it's not right. Even if she was a true employee of only 2 years, she would still be owed much more than 3 weeks pay. She probably would have been owed 4 months pay. But remember what I said, she was recruited from another job, induced exactly to leave another position. So what happens in that situation? If you're working a secure job, you've been there for a while, a new company comes and says, "Hey, we want you to come work for us." You decide to do that, only to be let go at some point down the road. Well, now, because you were induced, because you were recruited from another position, you're probably owed enhanced severance that recognizes the time with the previous company. So for this lady, she's not really a 2-year employee. She's a 12-year employee.
Wow, difference.
The 2 years plus the 10 that she had with the previous company. And that's how the severance is going to be calculated, as a 12-year employee. So she's probably owed a year's severance, maybe even more than that, even though she only worked for the company for 2 years. We call this inducement. It's a very common situation. If you've been recruited from another company and then in the first 2-3 years are let go, you may be owed enhanced severance. That could mean 2, 3, 5, 10 times the severance you would have been owed otherwise. That's why it's so important to get that advice. For her, instead of 3 weeks pay, John, I'm going to help her get about 12 months pay, maybe even a bit more than that, because of this inducement factor.
I think an obvious question from employer number 2 would be, is there a best before date on how long I have to include the previous, 10 years and it works for me for another 10, she's not 20 at this point, is she?
Usually 4 to 5 years. If you've been there for 4 or 5 years, then at that point, we're not going to be looking that far back to to account for your previous service. The other thing an employer can do is to have an employment agreement specifically saying, we're not going to recognize any past service. But if the employer doesn't do that and does let go of the person in the first 4 years or so, they may have to pay enhanced severance, which again, that difference could be massive.
Yep. 1-855-821-5900 is the number to reach out anytime. EMPLOYMENTLAWYER.ca, that's the website. Go there, find the radio show, listen to it, enjoy it, and learn just like you do on this TV show. We always pull some of the phone calls from the radio show onto here. Don't have the visual, but get the audio. Works just as well. We'll get to our first call of the day right now.
I had a strange situation, just looking for advice. It's a relative, and he was employed at a charitable organization, so his boss is a board.
Yep.
And he was fired, and he was offered some severance, but it wasn't adequate, so he asked for more, and the offer was withdrawn. So he was given no severance, and so he's just wondering what to do next.
Can I have more, please? Went for the Oliver twist. It didn't happen.
Pan out. Well,
Yeah.
you know, the first thing I'll say, before I even talk about the issue of withdrawing the severance,
Yep.
I want to talk about the fact that this was a charitable organization. Let's be very clear. If you work for a charitable organization or a not-for-profit, the severance rules are the same. Okay?
kidding.
So you
Okay.
get the same severance if you work for a major corporation, a bank, what have you, or you work for a non-for-profit or a charitable organization, or even a religious organization like a church or a synagogue. Your severance is going to be the same. It's calculated in the same way, your age, your position, and the length of your employment. But let's talk about the specific situation. The person was offered severance, and they said, well, we don't think it's adequate. Maybe they went to pocketemploymentlawyer.ca, but it wasn't adequate. So because they had the audacity, quote unquote, to ask for the proper severance, that offer was withdrawn. Nonsense. It cannot happen that way. You're owed what you're owed. And the company can't decide not to pay you severance because they don't like that you asked for more. It's ridiculous, it's silly, and it's illegal. So let me give you an example. If I owe you $100 and I say, John, I'm going to pay you $50, and you say, oh, well, no, Lior, I want $100. Can I say, well, now I'm not going to pay you anything?
No.
Well, that's silly. That's absurd. Well, this situation is just as absurd. This person is going to be owed their full entitlements. It doesn't matter what their employer wants to do. So you should never be worried about asking for what you're owed. The law decides what you're owed. Not me, not you, not your employer. If you're owed 12-month severance, you have to get paid 12-month severance. If you're not sure how much you're owed, if you're not sure if that offer is adequate, two easy things you could do. You can reach out to me, or even simpler, because you could do this right now, grab your smartphone, go to pocketemploymentlawyer.ca.
I think that's a realistic problem for anybody in the workplace thinking, A, I've got a deadline on this severance offer, and B, if I don't take it, they're not going to give me anything. They think that.
It's a pressure tactic,
Right.
and you know, some employers even kind of convince themselves that they can do that. They cannot. Now, a sophisticated employer is going to realize, no, we can't do that. Oftentimes, these smaller employers may not appreciate their own obligations. They may think that a severance is a gift they give to the employee instead of a legal obligation. So don't worry about deadline. Don't worry about pressure tactics. You have up to 2 years to pursue your entitlements. Make sure you do the smart thing so that you don't sign it and then find out, wait a second, they owed me another 6 months' pay and I walked away from it. You don't want to be in that situation. Every single week I speak with people where that's exactly what's happened to them. And if I never have to do that again, I will be very happy.
You spoke the words just a minute ago, pocketemploymentlawyer.ca. Give me some details.
So I touched on it, and we'll touch on it even more on this show, future shows, but it's a tool that I created to allow people to find out, to analyze their legal situation and get advice. You know, technology is wonderful and it can do so many things. So I wanted to make it as easy and accessible as possible to get answers to your specific questions. So pocketemploymentlawyer.ca, again, pocketemploymentlawyer.ca. You now essentially have a smartphone, you have an employment lawyer in your pocket with you at all time. If you're not sure about, hey, I've been constructively dismissed or not, they've changed my job, is that legal? Pocketemploymentlawyer.ca, and answer a few questions and you'll find out, is that a constructive dismissal or not? If you're not sure if you're an employee or an independent contractor, you go to pocketemploymentlawyer.ca, answer about 3 or 4 questions. You just pick them from a drop-down menu and you'll find out if you're an employee or a contractor. If you're not sure if there's cause to let you go, if you're not sure if your situation is considered harassment, or if it's considered a human rights violation, or maybe you're not sure if the insurance company was right to cut you off disability. All this and more you can find out by going to pocketemploymentlawyer.ca. It's free. It's anonymous. It takes very little time, literally seconds. You can go through that exercise and have that information available to you. In the past, up until I created this, you would have to call a lawyer, make an appointment, sit down and go over this for the lawyer to tell you, yes, you have a case, no, you don't. No need to do that anymore. We've changed the way things work. Go to pocketemploymentlawyer.ca. Even if you're curious, check it out. Love to get your feedback. And of course, if you want to, there's a button there that you can use to contact me, only if you want, so that I can help you enforce your legal rights.
It really is a robust tool, but we could talk about it forever, or we could take it out for a spin, as we like to say in the show. I want to read you an email that we got. This from help@employmentlawyer.ca as follows. Says, I was just terminated for cause after an argument with my manager. They wanted me to work on a project with a colleague, but I told them it would be more than double my workload. They said they had no choice but to fire me due to insubordination. It's like the military. After 3 years with the company, should I get a second chance?
So, silly. Remember what we said, first of all, before I even go to the pocketemploymentlawyer.ca, how difficult it is to terminate someone for cause. Not to terminate someone. It's not difficult to terminate someone. It's extremely difficult to terminate someone for cause, meaning you don't get severance. That's only a situation where you've done something so bad that it's just impossible to continue employing you. So the question is, this person saying, no, I'm not going to do the job you want me to do. It's too difficult. It's not my role. Is that insubordination? Is that cause? Now, it may not be insubordination, or it may be insubordination. What it definitely isn't is cause. So let's, as you say, take it for a spin. Let's take that information and plug that into pocketemploymentlawyer.ca, as anyone could do, to find out if this actually amounts to just cause. So we can see on the screen there, the person inputs their information. They've been there for 3 years. They are accused of insubordination. They're not sure if that's true or not. It hasn't happened before. And we see the result on the bottom there. And it simply says, yes, this is a case probably where there's no cause for termination, meaning that you are owed your severance pay. So this is automatic. You got that information. You know, wait a second. Even though my employer said there's cause, it's not cause. Now I know I have rights. Now I know I have my full severance entitlements. It's that simple to use. pocketemploymentlawyer.ca.
We'll take a short break. Still to come, everything you need to know about maternity and paternal leave. That is on the way, so make sure you stick around for that. It is always the elephant in the room when it comes to employment law, for sure, and the do's and don'ts as far as that is concerned. 1-855-821-5900 and employmentlawyer.ca to reach out further. Lots more. The Employment Law Show is on the way. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to the Employment Law Show. John Scholes and Lior Samfiru. I'm the host. He's got all the knowledge. He's a lawyer, so he answers all the questions. I just kind of sit here and try to look pretty as I can.
Try to look.
We did mention when we went into break everything you need to know about maternity and parental leave. I said this is a big topic. That's why we're talking about it, right?
It is a big topic, but unfortunately, it shouldn't be. It should be straightforward. It should be a topic that people, employers, employees get right without too many things that are controversial, but it is still something that I have to deal with all the time. And if you're going on a parental leave, you need to know these things. Or if you're an employer that have employees going on a parental leave. So we're going to try to give you the straight goods as simple as possible so that you know what to do in those situations.
First question, obvious one, who qualifies for it?
So obviously a parent, and it could be an expecting parent, a parent that are about to have a kid, or someone that's adopting a child.
Okay.
Qualify for time off work. You have to have worked for the company 3 years. For 3 months, I should say, 3 months before the due date or before the child, if it's an adopted child, comes into your custody. So if you've worked for the company for 3 months or more, then you qualify to take a leave of absence, a protected, and this is the key, protected leave of absence. Again, that cocoon of protection, as I like to call it, is around your job, meaning you have a right to be off, you cannot be fired, nothing can happen to you. You can take that time off as long as you have a child and that child either comes into your custody or you're expecting it, you've been there for 3 months, you have a right to take that leave of absence.
Once you're on the leave, how long can it last for parental leave?
So parental leave right now can last up, including what we call pregnancy leave, in terms of the time that you can be off, up to 18 months. Okay, so it used to be 12 months. So the government changed that recently. So for 18 months, you can be off work, which means that protection is for up to 18 months. Now, if you decide to take 20 months, then the employer doesn't necessarily have to keep that job for those last 2 months for you. They can say, well, no, now we're not going to do that. Now, that could still be a human rights issue, potentially, but the general rule is up to 18 months, and it doesn't have to be that long. Some parents may take less, some parents may take the full 18 months, but for 18 months, your job is frozen. Your job is there waiting, available to you, same compensation, same role, same location, for up to 18 months, John.
Everything you need to know about maternity and paternal leave, or family leave for that matter. Next one is, can you change the end date?
Yeah, and this is a very common question. Sometimes someone thinks, okay, I'm planning on taking 12 months. And then the baby comes, you realize, wait a second, I'm not ready to go back to work after 12 months or however long it is. You want to change the time. Yes, you're allowed to change the end date, again, as long as it's 18 months. Now, strictly speaking, you're required to give your employer some notice, but our courts have said that even if you don't provide enough notice, your employer still cannot punish you. So, as a practical matter, I always say give your employer as much notice as possible. But if you had told your employer, I'm going to be gone for 12 months, and then you decide, you know what, I really want the full 18 months, that's okay. You can change that date. You can tell your employer, I'm not going to come back after 12. I'm going to go for 14 or 16, or you may say 14 months and then realize you really want to do 16 or 18. That's okay. As long as you're within that 18-month period from when the child is born, you can take that time off. Your employer cannot do anything. And if you don't know, that's okay. Give your employer the approximate end date. And if and when you realize that you need to change that, let them know, and they have to make that happen.
I'm going to lob the easy one over the plate here, and that is, can you be let go because you need to take that leave?
You know, it's so obvious, and I hope that all our viewers can say, well, of course not. Except I still every week have to deal with situations where a mother that's taking a leave or a father that's taking parental leave is let go. Now, it's rare that the company says, we're letting you go because you're taking a leave. They often try to come up with a different reason, but it's still illegal. You cannot be let go because you're taking a leave, even if the company is trying to use an excuse of finding another reason, okay? It's illegal. You have a right to your job. You cannot be punished. You cannot be demoted. I've seen situations, John, where a mother is about to take a leave. She's been a great employee, never had an issue. And as soon as she announces her pregnancy, now she can't do anything right. She gets warned, she gets written up.
Workplace pariah.
All of a sudden, somehow the pregnancy makes her an incompetent employee. Nonsense. Of course, that's not the case. What's happening there is the employer is either trying to come up with a reason to let her go or trying to maybe get her to quit. That's illegal. You cannot be punished, disciplined, or have anything happen to you if you're pregnant, if you're a mother taking a maternity leave, if you're a father taking a parental leave. Anything less than that, without exception, is illegal.
Last one, I'll ask you about this one. What are the rights of the employee at the end of the leave?
So an employer cannot decide, for example, well, we had to have a replacement covering for you while you're off, and that person was really good.
Rock star, yeah.
Rock star, complete superstar, we're going to keep them. No, they cannot do that. That's illegal. That person may be a rock star. You still have a right to your job. Not a different job, not a kind of similar, a right to your actual job. Now, if that job doesn't exist for legitimate reasons, nothing to do with you, maybe there's been a major restructuring, then they have to find you a similar job. But if that job exists, you have to take that job, and it has to be the same pay. Oh, and by the way, John, if compensation for that job has increased while you've been off, then you have to get that increased compensation. They can't say, well, you were gone, the salary went from 40 to 50,000, but you were making 40, so we're only going to pay you that. If the compensation went up to 50,000, you have to get the 50,000. Anything less than that, John, is a violation of the Employment Standards Act. It could also be a violation of the Human Rights Code. It's illegal. you have a right to your same job back, no exceptions.
If that money increase came a month after you started your leave, retroactively, or moving forward, should you have got the increase?
So keep in mind, you don't get paid by your employer while you're on a leave. You get paid potentially by EI. So you only start getting your salary again while you're back. So once you're back, they have to start paying you the increased rate, but they don't pay you retroactively because the company does not actually have to pay you if you're on leave. Some companies decide to top up EI, but anything beyond that, the company wouldn't usually pay you while you're on leave, you're going to get EI. They'll start paying you again once you're back from leave.
1-855-821-5900 is that number. EMPLOYMENTLAWYER.ca is the website. Go there to find the radio show from which we pull call number 2 for today.
For the past couple of years, I've been on disability, and recently I've been thinking I feel a little bit better. I would really like to return to work. My anxiety now is, what if I return to work? And I've heard horrific stories where people get laid off right away because company don't like people on disability.
How long have you been with this company?
16 years.
You come back and we're going to lay you off. That's nice.
And at this point, she's assuming and she's concerned that when she wants to come back, they're going to let her go. So let's kind of break this down a bit. So first of all, if she's been off, she continues to be an employee, she's been on a disability for a while, that's fine. If she's cleared to return to work, what she needs to do is provide her employer with the doctor's note confirming that she is able to go back to work. And once she does that, they have to make all efforts to take her back. They cannot let her go without considering bringing her back, without trying to find a position. The only time they can actually let her go is if it had nothing to do with her medical condition or disability leave. If they tried to find a position, there is no position available, maybe. But they can simply say, we fire people that come back from disability leave. That's illegal. That's a human rights violation. So there's really two aspects here. Is if they bring her back, well, what does that mean? Is that a human rights violation? And how much severance she'd be owed if that were to happen? Well, one way to deal with that is by going to pocketemploymentlawyer.ca. Let's see how much severance she would be owed. Keep in mind, that's if the termination is even legal. Yeah. So she's an IT professional. We can see here the printout from the pocketemploymentlawyer.ca. She's been there for 16 years. She's 45 years old. And if they don't give her any severance, guess what? She'd actually be owed 18 to 24 months' pay. So that's what she would be owed in this situation. That's a significant amount of compensation she's owed, and she may be owed even more. If she's let go because she took a medical leave, it's a human rights violation, which means she's going to get even more compensation over and above that 18 to 24 months of pay.
Let's take a short break. Coming up here after the break, what happens when you're caught with marijuana at work? 1-855-821-5900 and EMPLOYMENTLAWYER.ca. It's the Employment Law Show. Stick around. Lots more coming up.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
All right, welcome back to the Employment Law Show. John Scholes, Lior Samfiru, EMPLOYMENTLAWYER.ca. That is the website we direct everybody to find stuff like Pocket Employment Lawyer and the radio show where we do every week and take a ton of phone calls, talk to people. We love it, been doing it for years, and we'll get to our third phone call right now.
My wife, we ended up getting pregnant, so now she's doing 3 weeks, and then there was talk of her work relocating. They sent out a letter amongst the employees for them to sign. Either they want to be transferred or they want a package. They used to pay out 2 weeks per year for severance. Now they're saying they're only paying out 1 week.
So how long has she been there?
14 years, I believe. She's customer service. She's going to be 45 in November.
Yeah, so this is an interesting situation. They're saying, well, you can either relocate or we're going to pay you severance. So let's start with the idea that they can't actually impose a relocation unless it's minor. Listen, if it's across the street, yeah, fine. But if it's a real relocation where they're going to have to travel much further, then no, they cannot force that. And whether they want to pay severance or not, that would be a constructive dismissal at that point. You can also check pocketemploymentlawyer.ca to find out if your situation when you're relocated qualifies for constructive dismissal. So it's really going to be, if she doesn't accept the relocation, a matter of severance. Now, whether they want to pay a week per year or 2 weeks per year, it doesn't matter because they don't get to make that call. It's not up to them, well, we're going to pay you a week per year. The law is going to come in and say, guess one company, you're going to pay what the law says. So let's see what that severance is actually going to be. Again, pocketemploymentlawyer.ca to do this yourself. Take seconds, free and anonymous. So this person we see on the pocketemploymentlawyer.ca, she's in a customer service role for 14 years. She's 45 years old. And the company says, we're going to give you a week per year of service. That's 14 weeks. Not so fast. You see that on the screen right now. She's actually owed between 12 to 15 months of pay. Not 14 weeks, 12 to 15 months pay. Depending on her salary, that could easily be $30,000, $40,000, $50,000 or more.
Right.
So that's how easy it is. If she's relocated, she can say no if it's a significant relocation. If as a result of this, she's terminated, not a week per year of service, potentially much, much more.
Another way for you to reach out, ask your questions, terminationquestions.com. You've heard us talk about it before. For today, this is the one how it comes down, pal. It says, I was fired from my job after HR learned that I brought a bag of marijuana to work in a travel bag. I never planned to smoke it at work and have never been high at the office. I also have a clean discipline record. Can they just let me go like that?
The answer to that is no. Now, keep in mind, for a company to prevent or to say we're not going to allow you to bring marijuana to work, they would actually have to have a policy. Now, it's not illegal anymore. It is legal to possess marijuana.
Right.
Now, that doesn't mean that a company has to allow it at work. But for them to prevent people, for them to prohibit people, they have to have a policy. They have to have something in writing that says, our policy is you are not allowed to bring marijuana to work. They can do that. Now, for them to have a policy like that, not only does it actually have to exist, they need to communicate that to individuals. They need to make sure that people know about that policy. They know that there's zero tolerance to that. Now, if despite this, the person knew about the policy, there's a good policy, and he brought marijuana to work, so that person has done something wrong. Does that mean that they can be fired for cause? The answer is absolutely not. Now, they did something wrong, which means they can be disciplined. Maybe a warning, maybe even some sort of a suspension.
Steps taken. Yeah.
Steps taken, but you don't jump straight from nothing to the worst punishment, which is a termination for cause. The fact that this person may have brought marijuana to work, if there was a policy, maybe they've done something wrong, probably they've done something wrong, but that does not mean you could be terminated. Now, I'd feel differently about this if marijuana was still illegal. If you brought illegal substance into work, the employer should not accept or tolerate that, and yes, they could be terminated. But now that it is legal, it's no longer a big offense. Your employer can still prevent it, and you can be disciplined if you breach that policy. But that does not mean you could be let go for cause for employers. If you want to deal with marijuana, if you don't want to have that at work, have a policy, enforce that policy. But by enforcing that policy means you have to take steps. If someone does it one time, you provide a warning. If they do it 2 times, maybe you provide a final warning. And maybe after the 3rd time, you can say, that's it, we're going to let you go for cause. But you can't just jump steps in the queue. You can't decide that you did it one time, too bad, you're out of here for cause. You can terminate, but that's a without cause termination, and severance has to be paid.
And your policy can't be shoved in some drawer on the 7th floor. People have to have read it, if not signed off on it, right?
A policy, any policy, not just dealing with marijuana, any policy does the company no good if it's not communicated, if people don't know about it. I often see that when it comes to bonus policies. An employer may have a bonus policy that talks about that it's discretionary, that the company can change it, and that you may not get a bonus. But no one knows about that policy. They've never seen it. They always get the bonus. And the company only takes that policy when they want to use it. Nonsense. So a policy like that is meaningless. For any policy, John, a workplace policy, a workplace manual to have effect, for it to impact your workplace rights, you have to know about it. You have to have that explained to you, and also have to have accepted it.
Done for another week, and we'll see you next time. You want to reach out, 1-855-821-5900, employmentlawyer.ca. And don't ever forget, pocketemploymentlawyer.ca. We'll see you next time. Thank you.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.